Hi, everybody. I'm immigration lawyer John Khosravi. Thanks for joining us today. We're going to do our regular session where we take your questions live about U.S. immigration to see what's going on and how to fill you in and with some questions and answers you may have, because the immigration system, unfortunately, gets pretty complex with all the different things and rules that are happening. And it's a weird area. So we try to come here every Tuesday live to take general questions. And, we can't provide individual legal guidance because each case is different. We try to answer your questions the best way possible so you get an understanding of what's going on in the immigration, situation, and have some guidance to go on from there. We also give away 3 free video consultations for those watching the live show. So if you're watching live, and you can win a chance to, talk with me in a private chat, because here it's all general stuff. To get the private live chat, all you gotta do is like, subscribe, and ask a question. If you have a question, write consultation, or just write consultation, and we'll randomly pick a person around every 10 minutes. And so you'll see that happening. We're live on Facebook, on TikTok, YouTube, Instagram, and LinkedIn. So we're getting questions from all over the place. And all you got to say is try not to ask the same question over and over again. We're trying to keep track of stuff. It makes it difficult when you do that, or apply to be in the lottery multiple times. We get disqualified if you do that. Just a heads up. But we got questions already coming in. I just want to remind also people that if you're interested in a marriage case, a fiance case, get your green card through that route. We have a guide called John's Ultimate Marriage Green Card Guide, and it really fills you in on most of the stuff you need to know, especially if you're going to hire an attorney. You know the basic stuff, so you can go into hardcore stuff related to your case at your initial consultation instead of studying the process, because it's all there. All you got to do to access that is go to marriageimmigrationlaw.com. The website is marriageimmigrationlaw.com, and that'll help you out there on knowing what's going on before you talk with an attorney. And I guess with that, we'll get it started. I'm going to start with Instagram. First question, Mika asks, how long does the I-130 for a spouse take? Well, it depends how long an I-130 is going to take. If you're a U.S. citizen filing for a spouse, typically right now it's 12 to 13 months. It could be more, it could be less, and it could change 6 months from now. If you're a green card holder filing for a spouse, on average, it's like 1.5 to 2 years. I've seen them be approved in 3 months. I've seen them be approved in 2.5 years. So the timelines are very inconsistent, but most of them will be done in that time right now. Again, 3 months from now, 6 months from now, everything could be different. But the timeline on a marriage-based I-130 for citizen around 12 to 13 months, for a green card holder around 1.5 to 2 years, but it could be wildly different. Another question from Sefer asks, hi, John, how long does PERM process taking for a Persian? Question jumped around. Student OPT, if your office does it. Well, we do handle PERM. We have a senior employment-based immigration attorney that handles our employment cases. The PERM process right now is taking a while. The first step of it is taking like 7 to 10 months for the Department of Labor to do its analysis. And then from there, the I-140 filing could potentially be expedited. And the rest of it could be relatively fast. You got to see the details of your case, but expect over a 1 to 2 year process. If you're on OPT, we got to time it right, so it's very sensitive. But the best thing to do is to email the office, because the PERM, the employment-based green card, depends on your employer filing for you. So really, your employer needs to have a conversation and make sure they're willing to do all the costs and things associated with it to go through the process. But that's the general gist of it. We do have a consultation fee for the discussion, but it's start just email our office and let us know who your employer is and if they're interested in doing this, and we can take it from there. But thank you so much. And then Sadullah says, hi, John, is Form 1040 with W-2s and pay stubs enough to support ICE-864? My sponsor recently filed tax returns. I was transferable with that sometime. Well, it's not the forms. Like, yeah, you have to submit your 1040 or W-2 for affidavit support sponsor. But what's important is the amounts on there. So is it enough? No, those are just names of forms. I don't know what's in those documents. I don't know what kind of employment your spouse has, if they make enough or not. So it's best to talk with an attorney in private to see if they are or not, and to do that kind of review. Our office typically doesn't give piecemeal advice on this. We take the whole case because we want to take responsibility for any advice that we give. So if we contact our office on this, we want to do the whole case. So we have to recognize as a lawyer. So if there's any ups and downs, especially downs, we take full responsibility, then just give you, a piece of advice and say, on your way, or kind of thing. So, but the information you gave doesn't help. We need to know the actual information for your case before anyone could advise on what you're asking. But thank you for the question, Sadullah. We'll take some questions right now from YouTube. UK says, do I need to pay a biometrics fee for $85 for E80 renewal? CA, please answer. Check the rules on the I-765 website for USCIS. Typically, you always have to do a biometrics fee if there is there. But when it comes to this stuff, you got to check what the website says, and it'll specify right on there what the fees are for each type of case. USCIS.gov has a filing fee indicator page. So go to USCIS.com filing fee, or just type in Google USCIS filing fee. It has a system where you specify what kind of case you have and exactly what the filing fee is. That's the best way to do it to make sure to get the right answer. Mary John asks, hey, how long does it take to get a working permit after a biometric? So the timeline of getting a work permit is unrelated to the biometrics appointment. So I've had people get their work permit like a week after the biometrics appointment, and I have people 8 months now, they still haven't got the biometrics appointment. There's no consistent timeline, frankly, on when the work permit's going to come. So you just got to wait. There's just no consistency unless it's an emergency that you need the work permit for, and potentially you can request an expedite request. But practically speaking, I have not seen, and we do these kind of cases every day. This is our bread and butter, marriage-based green card cases. We file them every month, and sometimes the work permit comes in like 6 weeks, sometimes 6 months, sometimes 10, 12 months. So it's just too inconsistent to give a real answer on that. It's just not possible. I don't even think USCIS has an answer. You can average it out, but that's useless. Chad asks, what does it mean when USCIS sends you a courtesy email? They just sent you an email to notify you of something so you know about it. Believe asks, hello, I overstayed my visa while putting together my adjustment status package. I'm married to a U.S. citizen. If my travel authorization is approved, will I have any issues coming back to the U.S.? Thank you. So, when you overstay a visa status, if you're married to a U.S. citizen applying through that way, that excuses it. And typically, if you get advanced parole travel permission, it's permitted, because typically you can't travel when a green card case is pending. But if you get it, you could travel and come back. But when you say, well, I have any issues is an absolute statement. You may. At the end of the day, I don't control who's at the border. I don't know the details of your case, if you've been arrested or not, or have any issues in your back file. Maybe your name sounds the same as someone else who has on a target list for all I know, and they may hassle you at the border. I don't know what mistakes the government has regarding your file that they accuse you of. So when you say I will have any issues, that's impossible for anyone to understand, even if they know your case. But generally, advanced parole travel is not an issue in these kind of scenarios. But we advise against using it unless there's really an emergency situation. Some attorneys won't even file for advanced parole in this kind of case, a travel permission, because they don't want their clients to use it. I'm not so heavy-handed. I'm going to have the advanced parole in case there's an emergency situation that pops up where you need to travel, like something that happens to your family and you can't. But again, unless it's an emergency financial thing or a court case or someone in your family's sick or something like that, don't bother using advanced parole. You got to be cautious. You never know at the end of the day what's going to happen and what mistakes are going to be made. So best not to mess around with it. But the overstay itself typically doesn't create that fact doesn't typically create a problem, but just can't guarantee this stuff because you're dealing with the government. Leanne says, I was selected in the DV 2024 lottery and wondering about the process for adjustment of status. Currently working in the U.S. with an E3 visa and likelihood of being able to get approved before the end of fiscal year. Well, I mean, you got to wait till next year, and you got to go through adjustment of status process for diversity visa lottery. I'm not really sure exactly what your question is, but you just put yourself in there and hope for the best. That's about it. You have to have a clean visa history and all that kind of stuff to adjust status, pay the fees, and then wait to get approved. It's too broad of a question. I need to narrow down this particular thing, but that's about it. Just go through the process. Anthony says, can you travel to Puerto Rico if you have work authorization? So Puerto Rico is part of the United States, so you don't need to necessarily have a status to even visit there. Having said that, sometimes they mess up, and there are border protections sometimes there, and they can have problems with your case. So we generally don't recommend that you travel to Puerto Rico unless you have a proper authorization, although the rules fully say that it's not a problem. It's almost as if you're going from California to Nevada, but you're not. You get on a plane, and a lot of problems could happen. If you don't have official travel permission to leave the United States, a plane that you have to go to Puerto Rico can be redirected. There was a case I want to do a short video on this where a woman accidentally got on the wrong plane. She was going from New York to Florida, and they took her to Jamaica by accident. Now, if that was your situation and you didn't have a travel authorization or status or something like that, you'd be potentially banned from coming to the United States. So don't risk this kind of stuff, these kind of travel situations, unless there's an emergency. I do want to announce our first winner. My wonderful assistant, Katrina, announced Believe Acts 2315 from YouTube. Thank you for asking your questions and everything. If you'd like to schedule a private consultation, please email me, and we'll give that free video consultation. Take a screenshot of where you're watching this so I know your username as yourself. and email me at info@jqklaw.com, and I'll give you information about scheduling a private chat. Again, believe Acts 2315. For those just tuning in, we give away free video consultations. We have 2 more to give away. All you gotta do is like, subscribe, and ask a question or write consultation at the end of it, or just say consultation once. Don't repeat it over and over again. And we'll randomly pick someone in 10 minutes, 20 minutes to have a private video chat, because it's hard to give private advice here because it's a public scenario. So I just want to let you know. If you're interested in a marriage green card case, we have John's Ultimate Marriage Green Card Guide. I wrote it myself, the best one out there, 40+ pages for free. Go to marriageimmigrationlaw.com, marriageimmigrationlaw.com. I've had probably 100 people email me separately on their own and say, listen, we downloaded your guide. Thank you so much. Helped us so much. I'm happy to help. So definitely check it out. And if you don't have a marriage case, see what kind of stuff we have there. You'll be satisfied yourself to see what kind of good info is out there for free. So check it out at marriageimmigrationlaw.com. Let's go back to questions. I'll go to Instagram really quick. Tony asks, how does USCIS count 6 months that we can't leave the United States? Is it up for the naturalization form, data, or citizenship interview date? Your question is not fully formed, Tony, but at the end of the day, 100 days, 100 days. If you're asking about having a green card holder and not being absent, if you leave and you're outside for more than 180 days, it could potentially lead to losing the green card. Probably not. They're usually not that strict, but it could create serious problems for your citizenship. So don't have absences of more than 6 months or multiple absences of more than like 4 or 5 months repeatedly. That could be a problem. And Akash says, thank you, brother. You're welcome. Appreciate that, brother. Thanks so much. And let's get back to some YouTube questions. Ahmad says, I got my green card marriage-based, but asylum is pending. Can I travel to my country, please? I don't know your asylum claim. I don't know what you said in there. If you said, as soon as I step foot in the country, you chop my head off and then you go. So, I don't recommend it, but I don't know your claim. And so it's a decision you got to make if you want to risk it or not. Typically, it's not a problem, frankly, but I can't say it's okay. I don't even know you, and so I just can't give that okay without knowing what you said in your asylum claim to see if it's consistent with the ability to go back. So I've had people say, listen, if I go back, I can't find a job, they'll be prejudiced against me, but I could go. So in that kind of scenario, be okay. And frankly, there's people who said if I go back, they'll kill me, and they went back, nothing happened, and the U.S. government didn't say anything. But as a lawyer, I can't say that's okay. They've just been lucky that the U.S. has not been enforcing the rules. But it is what it is. But thank you for your question, Mark. User 86 says, it's been a year since we reported for marriage fraud. Who to contact if no answer from USCIS? I don't know that. I don't handle marriage fraud claims against other people. Magic asks, I have a qualified joint sponsor for my spouse's I-130 affidavit of support. It's for I-45, so we're okay. I, as a primary sponsor, I'm unemployed and have been for a few years. How do I fill out the tax information if there's none? That goes into filling out a form, particularly for I can't advise here, but there's a question on the form 864 that says, have you not filed your tax returns last 3 years? If you have not, you mark no and you explain why. And if it's according to the regulations for the IRS for you not to have filed, then you just specify that. But if you were supposed to have filed and you didn't, then you got to file them. So it really depends on what the IRS rules are, and you just let the government know. The form kind of walks you through as well as the instructions on how to do that. Darwin asks, can I use my receipt notice to get state ID in Florida? It's up to the state that you have. Typically, a receipt notice doesn't authorize you to anything, but I've seen DMVs make mistakes all the time. It depends on your local DMV office and what they want to do there. Tasty asks, I have humanitarian parole for my mom, dad, sisters, and brothers, and need quick response from USCIS. I don't know what your question is. You got humanitarian parole for them? Okay, then hopefully they hear. I don't know what you mean quick response from USCIS if your question isn't clear, Tasty. Does USCIS accept online marriages one party in USA and other in Africa? I've met many times. So the rule is that if you have an online marriage, either during or afterwards, you have to have seen each other in person once to consummate the relationship before filing for a marriage-based green card case. So, or any other kind of process, frankly, for their acceptance for non-immigrant waivers. But if you're talking about a green card case, after the online marriage, you have to go and visit each other once to keep proof of that. Sometimes I say, get together, hold a newspaper together, has a date, so you officially could establish that you're together, keep their airplane tickets to show you flew there, the passport stamps, all that kind of stuff, and the photo together, as I mentioned. But they don't. They don't accept what are called what's the word? I forgot the word for it. But they don't accept these online marriages until you see each other. And that's about it. A quick follow-up question on Instagram. Tony asked, my family's eligible for citizenship in February next year. Can they go to India in November and this year? If you have a green card and you have, you could always travel. But if you're outside too much, that's a problem. But if you're applying for citizenship, but you want to do a quick trip travel, that in itself is not a problem. Again, unless you file for asylum from that country, it's not a good idea. So, Tony, when you ask these very specific questions, there's always yes, but, and because I don't know the details of your case, I can't say yes because they may have an asylum issue as a problem. They may have been out for too long. There's a lot of issues that we need to go into, and so that's why, I give a generic one, but I can't advise onto something individuals like that. Farouk asks, I-04 is terminated. If I restart my green card process, I got divorced during the process. I don't know, Farouk. Your question isn't clear, and this is the form. I'm guessing you had a green card case, adjustment status pending, got divorced. I don't know how you want to restart it if you're not in that relationship anymore. I don't know what to do unless there was some sort of abuse and you want to claim a VAWA claim or something like that. I don't know, but you got to talk with an attorney in private. It's the best thing to do. ZA says, when do you think EB3 will be current for Canadians? No one knows. I need a crystal ball for that one. Unfortunately, they haven't given me one yet, so I can't answer that question. Desi asks, what are the chances of having an I-485 interview after I-130 is approved with that interview? 50-50. Either they do or they don't. It's not up to me. So maybe they will, maybe they don't. Maybe they'll do it they'll wait for everybody, but not for you. So these kind of chances and stuff don't make any difference in your life or anything like that. Either they do or they don't. Now, if he says, can you be deported after asylum is denied, and you also have a baby in the U.S. as citizens? Yeah, it's possible. I mean, you have to fight out in court, but it's not impossible. That just having children here doesn't give you the opportunity to stay in the United States. Unfortunately, that could be problematic. Animal asked, I'm having heart bypass surgery. I'm sorry about that. My asylum case is pending for 4 years. Can I apply humanitarian parole? Humanitarian parole is for you to be able to enter the United States. So if you're already here and you have an asylum case pending, humanitarian parole is not going to do anything for you. That's not the point of humanitarian parole. It's for you to be able to enter the United States. Justin asks, how does visa bulletin retrogression affect I-824 filed April 2021? Fall to join consular processing of my spouse who recently provided someone. It doesn't affect the I-824. It just affects your case. So the I-824 is just to have the case for the U.S. move to the embassy, and then that's it. But if your case is backlogged, you got to wait for it to be current for them to move it forward. So the I-824 is just a procedural thing you have to do, but the retrogression, the backlog that goes in your case is just, it exists whether if you filed it correctly the first time around or filed to join. If you do file to join, that you couldn't do it. But the most important thing is if you have minor children, because you have a spouse here, so I didn't get this conversation, but if you have minor children, how the Child Status and Protection Act would work to keep the kids who are getting over the age of 21 to be still part of your case. That's where the I-824 timely filing and retrogression when it happens and all this stuff comes into play. But if it's your spouse, it doesn't make really much of a difference in your case, other than the fact that I-824 takes a long time to get approved. Platform asks, I'm planning to change my status that came with ESTA. Will that be a big problem? Yes, you can't change your status if you arrive in the United States on ESTA. If you arrive on ESTA, the Visa Waiver Program, which is a program where certain people from passport holders or citizens of a certain country can come to the United States without getting a full-blown tourist visa, the electronic status travel authorization or something like that, a Visa Waiver Program. There's only two things you can do on the Visa Waiver Program. One is marry a U.S. citizen or be the parent of a U.S. citizen or a minor child U.S. citizen. You could adjust status in those scenarios if you're that immediate relative of a U.S. citizen, or you're filing for asylum. Other than that, you cannot do anything else on ESTA. That's part of the agreement you made when you completed the ESTA application online, that you're not trying to change status and you only stay within 90 days and not violate status. So there's nothing you can do in that scenario other than those two exceptions I mentioned earlier. Layla asks, hi, I'm a DACA. And DACA is a special program for people that were entered in the United States as children and they get social permission to be here. And my parents and sisters are U.S. citizens. If parents were to petition for me, how long would the process take? So it depends. So your parents are U.S. citizens. I'm guessing you're an adult child of a citizen. First, we want to look to see how your parents got citizenship. Probably your siblings applied for them. That's probably what happened. But you'll be in the, if you're single, if you're not married, if you're single, you're in the F2A category. The timelines for this stuff, it's not reliable because it changes, goes back and forth, and longer or shorter so much. So whatever answer I give right now is not going to be consistent. Maybe it's going to change in 6 months, a year, 2 years from now. But as of the most recent visa bulletin, and take it as you want, they're approving adult unmarried children of citizens that were filed in December 2014. Now, if you're from Mexico, that's another thing I need to know what country you're born in. They're handling cases through 2001. That's crazy. So if you're adult unmarried child of a U.S. citizen, but were born in Mexico, they're doing cases from 20 years ago, 22 years ago it's going to take. But if you're from, like, say, China, for example, it's they're doing cases that were submitted 9 years ago. Now, just because I say they're doing cases from 9 years ago, doesn't mean it's going to take 9 years. It could take 11 years because this line doesn't always move consistently. So the answer is it's going to take a long time, many years. We try to find some other exceptions in your case to see what would work, but there's no exact answer because that's a moving target. Sanjay asked, can we replace an I-130 to 360 while I-485 is pending? That's possible. For example, if you do a marriage-based I-130 adjusting the status and your spouse passes away, your case automatically is converted if you already filed and it's pending to an I-360. It depends on what kind of case you have. Well, many times you could transfer the I-485 to other types of cases, but it is discretionary in certain instances. So we gotta see what's going on specifically and what I-360 basis you have. Bugs asks, hi, if a parent has multiple entries in the United States, is lodging an I-130 for parents when they're visiting advised, trying to plan ahead as the petitioner isn't a U.S. citizen yet? This is, I can't advise you, Bugs. First of all, you have to be a U.S. citizen to file for the parents, and once you're a citizen, you file if they're here. This goes into too much legal advice that's individualistic, but it's not impossible to file for the I-130 whether it's here or not. That's not impossible. Let's just put it that way. Eurozag has best advice for IR1, spousal green card, long distance application process. Just get started sooner. Maybe throw a K3 petition in there as well to speed it up. I-129F K3. Who knows? It might get a little bit faster. Ganesh asks, is it important to have a joint bank account to prove a bona fide marriage? It's helpful if you really have a joint bank account, but if you don't, it is what it is. Not everyone has joint bank accounts, so just try to make up for other stuff and to show your relationship history, personal letters, statements, friends and family, photos together, travel records. You went to Disneyland, you got pictures together and tickets that have your names on. There's a lot of different ways to do that. Really quick, I forgot to announce the winner of our free video consultation, Magic Gamers from YouTube. Thank you for joining the show. If you want to lock in your free video consultation, take a screenshot of where you're watching this so I could see it's you and email that screenshot to me so I can see your username, and I'll reply with information about scheduling the private chat. For those just tuning in, we give away free video consultations. Magic Gamers just won one. We have one more to give away in 10 minutes or less. And all you got to do is like and subscribe and either ask a question, write consultation at the end of it, or just write consultation just once and not repeat it. And we'll randomly pick somebody, my wonderful assistant Katrina will, by the end of the show. And so we have a private chat. Here it's just, there's only a limit how much general information I can give. We get into more detail during that private chat. So let's go for some more questions. Layla says, thank you. Justin says, thank you. You're welcome. You're welcome. So Ellie asks, what happens if domestic violence case dismissed while green card processing? What would happen? Well, I don't know if you're the petitioner, the applicant, or whatever, but it depends on your case. And then what was involved in domestic violence. Even the case was dismissed potentially. If the police report says some crazy stuff, they can still get you on it. It's not guaranteed. I've had cases like this approved, but there's a lot going on here that we need to get down to because it's a serious charge. And accusations could still hold water, and a lot depends on your history and what the police report says and all that kind of stuff. But I've had some pretty gruesome stuff approved that were dismissed in court. Coco asks, does USCIS approve? Do USCIS approve I-130 for an interview? If they're gonna do an interview, they approve the stuff afterwards, or at least the I-485 afterwards. But they're mostly waiving these interviews right now, so they wouldn't even bother doing the interview. They just approve it most of the time. Michael says, what happens if you don't have info about your parents' report on your I-130 since you don't know? Then just write, I don't know. It's not against the rules. Just tell them you don't know. Now, if you're in the United States, just write, I don't know. Yeah, it is what it is. Not everyone knows that stuff. If you're in a relationship, you're in a relationship. Julia asks, can she adjust in the USA coming from a question about green card holder petition adult child? No. You have to have maintained lawful permanent residency consistently. If you're on DACA, it's not status, so that prevents you from applying unless you have a thing called 245I, which is you're on a petition pre like 2001 that was pending. It's an exception there. So that there's some nuances in there that may be possible, maybe a VAWA petition for abuse. So there's some stuff that may allow us, so there's exceptions, but generally it's going to prevent that from happening. James says, when is F2B final action days going to start move? Yeah, unfortunately, the visa bulletin hasn't moved on these family cases. I don't have any information. No one has information, even the government, on when it's actually going to move. Hi, after I volunteer, Group says, hi, after voluntary departure, can I apply for a new visa to visit the U.S.? You can. You just got to make sure you're not banned. If you are, you have to apply for probably a 212 waiver. So you probably are going to need a waiver, but I have to see what happened in your case, what the history is. There's fraud accusations or misrepresentation. So you'll probably need a waiver, but it depends on the facts of your case. But you apply, you're probably going to get denied unless there's a good reason for you to come. But give it a shot. Elizabeth says, is it okay for my mail to go to my mother-in-law address? What's the effect showing bona fides? No, if you want to have a different mailing address, that's fine. Just, might be moving or just a more reliable mailing address. It is what it is. It's just mailing address. I mean, you never know. Some officers might be wacky and think it's a big deal, but I wouldn't stop me. If you feel more comfortable mailing them somewhere else, it is what it is. Julie Burns asks, as a green card holder, can I petition for my adult child single from Peru? She entered with a visa at 1 year old. She has DACA continuously since 2015. She traveled with advance till 2015. So how old is she now? 1 year old, continuously since. Probably, can I agree? You could petition. Anyone could petition. So the I-130 petition is just to establish the family relationship that you have. So yeah, you could petition. I think the question you're going for is, can you apply for a green card from within the United States or even through the embassy? That's the bigger question. Probably won't be able to apply for a green card in the United States because she has a continued lawful status. She had lawful entry and then continued lawful status. Probably will have to go to the embassy to get the green card. But the I-130 petition, with the question asked, which I don't think should be is probably really what you get at, that you could do. The bigger issue is less stuff. But my wonderful assistant Katrina just named you as our raffle winner anyway. So Julie Byrne, take a screenshot where you're watching this. So I know it's you, and email it to me at info@jqklaw.com. And I'll reply, and we can have a private chat where I could break this down, get more information from you, and answer more fully during that free private chat. Thank you so much. For those just tuning in, we give away free video consultations. Just give away a third one to show us hours and hours of free content, not just on videos on YouTube and all the other places, but also in private. We help a lot of people. Had over 100 people have thanked me for help, free charge, no stuff, and it's no problem. We're here to help. That's the role of the lawyer in society. We got to do some work to help society. It's not all about getting paid. So tune in for our next show. I'll have 3 more free video consultations to give away. And a lot of your questions, frankly, 99% of the questions here already answered on the main YouTube page for JK Law called Immigration Talk, or on our clips page, Immigration Talk Clips. But y'all could always ask here, but that's a faster way of finding the answer because I've been doing this for over 3-4 years now. And so we have like 1,000 or plus clips that answer every question. They don't get too many views, unfortunately, but the answers are already recorded and they're ready to go. I'll take a few more questions and we'll call it a day. So next question from YouTube. Mohammed asks, how long does it take for my green card replacement to arrive? 3 months to 3 years. Usman says, I'm an active restraining order against me. Will this affect my wife for her I-130 approval? Not necessarily. I mean, it could. It depends on what the facts are around the restraining order. Typically not. But it depends on the facts. Like if you're, accused of child abuse or you're going to get convicted of child sexual misconduct or something, yeah, that could be a problem. There's out of Walshak. So that just saying restraining order doesn't give you enough information to be able to answer that question. Willie asks, which bars adjustment question should I select if I have not violated my immigration status at all on my I-485 supplement? Why are you using I-485 supplements if you don't? Which bars adjustment question should I select? If you haven't violated your immigration, I'm not even sure why you need to use an I-485 supplement, Willie. So I don't even know where you're getting to that. Are you using 245I? Then it doesn't make sense. You would have violated something if you did 245I. Isla says, we got married 7 years ago and he refuses to apply. He has a misdemeanor on his record. If there's abuse of some kind, and some lawyers say this is considered abuse, you can file a VAWA claim, Violence Against Women's Act, to say this person is being abusive in that kind of way. That may be the way to bypass having your spouse do the case for you. Some lawyers are having success with that route, but it's something to think about. Chef asks, can I apply for change of address in the middle of naturalization? Yeah, you have to. If you move, you have to. So you use Form AR11 to do that. Samuel says, can a green card holder's spouse work without any proper documentation after filing I-485, like U.S. citizen spouse? And the law is no. If you do work without documentation, if you're married to a U.S. citizen, they don't hold it against you. However, you shouldn't fill out a document that says I'm a U.S. citizen to get that job, or use a fake ID to get that job. But you're not allowed to. It's against the law. But for immigration purposes, just for the green card, if you have unauthorized employment, there's no fraud or misrep or false claim of citizenship involved, they don't hold it against you. James asked, the National Visa Center Immigration Visa Backlog Report went from March to May without April. Did they forget the April? Or this is a situation. It's not consistent. When I talked to them, they have a report that says how long these are taking, and they forgot apparently to release the April one. I never bothered looking at this stuff because, frankly, although it's good clickbait and even like have it in my newsletter, I always see people clicking on it. None of this stuff makes a practical difference in your individual case because your case is your case. And these general estimates and numbers and stuff don't make a difference. So I wouldn't even bother thinking about that. Platform follows up. I'm coming to the U.S. on ESTA from the UK. When will it be best to file the I-130 after 90 days or just before my 90-day mark? Thank you. If you're coming to the United States to apply for a green card adjustment of status, you're not allowed to use your ESTA for the actual intent of filing a green card case. If you're just going to do a standalone I-130 and you're going to do consular processing, you can file it before you come, while you're here, after. Probably better to do it after if you're going to do something. But you can't enter the United States with a temporary visa, like a tourist visa, or ESTA, which is essentially like a tourist visa with those exceptions of how it works. So I can't recommend you do that and plan that out to do fraud. Jerry asks, we have a marriage-based green card application and applied this past March 2023, married on February. I have very limited pictures of the start of the relationship. Is that important to have? Not necessarily. Just try to do with other stuff. It's not the worst thing. We'll take two more questions. James asks, does a crisis at the border does a crisis at the border take immigration resources from other immigration categories for the government? Yeah, big time. It's a big cost. Other kinds of asylum cases are getting, denied because of that, are not getting interviews. Yeah, it's a big distraction. CBP resources get taken, but that's the situation. And last question, let's say, how long does it take to get an interview with a permanent resident? And there's no answer to that. And so we'll get one more question then. If I applied for the I-130 by myself and I'm looking to hire a lawyer for the next step after approval, how much will the lawyer cost? It depends on your case and what is involved in it, and your finances for the affidavit of support, what kind of relative it is, how many people are in the application, what kind of evidence you have of relationship, what kind of documents you're missing or not missing. It depends on your case, and every lawyer is different. It could be 1,000, could be 2,000, could be 5,000 or 6,000, all over the place. But thank you for your question, James. Thank you. You're welcome. And that's it for today, everybody. We'll be back again next Tuesday, 5 p.m. Pacific time, 8 p.m. Eastern. Take your questions, so general questions for general education purposes about U.S. immigration law. If you want to schedule a private consultation with me or one of my associates, just email us and briefly describe your question at info@jqqlaw.com. I appreciate you all. God bless. Be safe, and we'll see you next week. Bye-bye.